So hello, everybody. Thank you for coming to the webinar we are offering on the Wayfair decision. Our goal is to give you some context about what went before the decision to help understand what might be coming next and what kinds of things might happen and what kinds of things probably won't. So I have here with me for this webinar, Michael and Paul. So we'll start with Michael, who is going to be our question wrangler. Michael, would you like to introduce yourself?
Hi, Michael O'Brien from Mob Advocacy, and look forward to learning a lot and fielding some great questions.
Yes, this is a great topic. I look forward to learning about it as well. Michael is my usual partner in crime if you have come to any of our BillTrack50 webinars. So we like to do this together. And then we also have Paul, who is our expert in this topic. Paul, would you like to introduce yourself?
Yes, hi, my name is Paul Jones, and I'm a reporter with Tax Analysts. And I've been covering remote sales taxation since prior to the Wayfair decision last year, and I've been focusing a lot on the fallout subsequent to the decision.
And the fallout has not finished, I believe. Is that correct?
Yeah, no, it'll be ongoing for some time.
Right. So I am a small business owner, and I am quite concerned about Wayfair and what it's going to mean for me. So that is the angle that I'm coming at this from, is the things that I want to know. So we're going to start with background, as I mentioned, and then we'll get into the decision itself and what it actually says, and then of some of the aforementioned aftermath to talk about what might happen next, and then sort of a longer picture of the future. And then, of course, we will answer your questions. And you may have noticed that none of us are accountants and none of us are lawyers. So if we are anything, we are wonks. So we are talking about the kinds of legislation there is and what we anticipate to be coming. We aren't really qualified to give specific tax advice for your situation, but we are happy to answer questions about what we think is going to happen with different situations. So feel free to interrupt us along the way and ask your questions. When Michael thinks that we should stop and discuss your question right away, we will. Otherwise, we will cover them at the end, but go ahead and type them in as they occur to you so that they're out and done and you don't have to remember. Also, we will be sharing this presentation with you. So you will get an email with a link to these slides. So you'll notice there's a number of links in here. So you'll get all of these resources that we're sharing. We also have a blog post that Paul generously wrote up, a bit of a tome, going over all of the material we're talking about today. So if you'd like to review anything that was said, that is available at BillTrack50.com, and also includes many of these links, especially including the resources that we're going to give you at the end for different things you can look at to help with compliance and whatnot. All right, so you don't have to worry about jotting down URLs or anything like that. We're going to give them all to you. You will get them in an email tomorrow with our thank you for attending today. All right, so with that said, let us get on our way. So, Paul, I think we should start with some background. So let's talk about the history leading up to Wayfair, which means let's talk about sales tax.
Yeah, we can cover this pretty quickly, but just to remind everyone, with sales tax, when you are a customer in a state and you buy a product from a seller, they are generally required to collect sales tax from you and remit it to the state tax authority, typically for goods, although there are some states that charge it to services. And there are also some states that do impose the tax on the business and not the buyer, but generally it's on the retailer. And then there is use tax. When someone in a state purchases a good or, depending, a service from out of state, the state requires them to pay an equivalent tax and remit that to the state themselves. And so that use tax was created to allow states to get revenue from purchases their residents make from out-of-state sellers. The problem, though, is that while you can require a seller in your state to collect and remit the sales tax, the use tax is technically something that the customer is supposed to pay to the state, and compliance has never really been very high. So while the states have the authority to require purchasers in their states to pay the use tax to the state tax authority, they generally have not had much success in generating a lot of revenue from that because people don't comply.
Right. So the idea is if I buy something on Amazon, I'm supposed to tell the state of Colorado that I did that and then send them the sales tax, essentially.
Yeah, and you've seen states like California, for example, adopt rules that there's now a section on the California tax return that requires you to estimate the amount of out-of-state purchases you made in a year and thus the amount of sales tax that you owe, or use tax, I should say. So there have been some efforts to try and improve compliance, but generally it hasn't been very successful.
Right, because if I don't do that, and I might not, then Colorado's not going to have, I mean, how much am I worth? So going after individuals is not a sensible way for them to get their tax. So that's the situation, right? They're not getting the sales tax for things that were sold outside of the state.
Right. And that's why you've had a lot of people act for many years as if the internet was quote unquote sales tax free. But in reality, they're supposed to have been paying use tax. They just haven't.
Right. But, you know, it's been sales tax free. Okay, so starting before the internet, there was still remote selling, right? So let's dive into what the first case here that kind of sets our scene.
Yeah, so there are a couple key cases to understand the sales tax environment prior to the Wayfair decision. And the first one is National Bellis Hess versus Department of Revenue of Illinois. That was an important case because the Supreme Court decided that if a seller does not have a physical presence in a state, then the state can't require it to collect and remit the state's sales or use tax that's due on the sales it makes to that state's residents. And specifically, the court said that the Due Process Clause and the Commerce Clause both require physical presence by a seller in that state in order for the state to have essentially the jurisdiction and the ability to require the seller to collect the sales tax or the use tax due from the customer and then provide it to the state's tax authorities.
So for years and years, the physical existence in the state was kind of the key thing that you would. Right. All right.
Then Complete Auto comes along in 1977. That's important because in Complete Auto, the court established a four-part test, or four-prong test, I should say, as to whether a tax essentially is constitutional with respect to the Commerce Clause. And one of the key measures, one of the prongs is, does a seller have substantial nexus in the state? So that was an innovation by Complete Auto. Then in 1992, we have Quill. And in Quill, the court is again looking at remote sales tax collection obligations for out-of-state sellers. And it kind of goes back to Bellis Hess and says, actually, for purposes of due process, maybe a seller doesn't actually have to be physically present in a state for that state to essentially have jurisdiction to require them to comply with tax rules. But for purposes of I think the dormant Commerce Clause, it does need to have physical presence. And because of that decision by the court, essentially people decide that physical presence is a bright line test that is necessary to satisfy the substantial nexus prong of Complete Auto. So under due process, you don't necessarily have to be physically present in a state, but for a state to require you to collect and remit sales tax on your sales to that state's residents, you do have to have physical presence under the Commerce Clause.
So can you remind us what the Commerce Clause says?
Yeah, the Commerce Clause is essentially there to ensure that you can have interstate commerce that you can have commerce between states. And it involves, among other things, preventing, I should say, states from erecting barriers to interstate commerce by coming up with regulations or rules, unfair restrictions, et cetera. So in Quill, the court's concern is that if it's too difficult for a remote seller to comply with all these different states, complicated state and potentially local taxing jurisdictions, and all of their different tax codes at the sales tax level, that will discourage interstate commerce. It will overburden these sellers.
And we are trying to be one country with one economy, and the Commerce Clause is trying to help us do that.
Right. So they decide physical presence is a good standard. And notably, I should add, because the court decided that it wasn't necessary for physical presence under due process, but that it was necessary under the Commerce Clause, that sort of kicked it over to Congress and gave Congress the option to try and craft federal law that would allow states to collect or to require remote sellers to collect and remit sales tax.
And did Congress get right on that, like they always do?
No, they introduced bills and they debated bills and they introduced bills and debated bills and nothing ever happened. And it resulted in, as the slide shows, a lot of pressure building.
Right. So their bills, they tried and didn't quite get anything passed. So then the states who really do want their money, as more and more money moves to the internet, right? They're losing sales tax revenue because, commerce is moving online. So they're pretty, motivated to try to get some of that sales tax. So what are some example creative ways they define physical presence?
Yeah, no, it's absolutely correct that as some of these earlier decisions had to do with a mail order economy, but as online commerce grows, it becomes a much bigger percentage of sales that are occurring online and thus remotely. So states start saying, look, we're stuck with this quill standard. There have got to be ways to establish physical presence other than having someone own a store in the state. And so we have, for example, affiliate nexus, where if you are a company that's part of a larger group that has another entity in the state, that counts as physical presence, requiring you to collect and remit sales tax on your sales to states' residents. They have something called click-through nexus, in which if you are paying a website operator in the state to direct people to your online portal for sales or your website, then that counts as physical presence, requiring you to collect and remit sales taxes.
Yeah.
And when we got closer to the Wayfair decision, we even had some states looking at this thing called cookie nexus, which was the idea that if an online seller installed a cookie, a bit of tracking software on your computer's hard drive, that was a physical footprint by their business in the state.
Right, the cookie nexus. Okay, so with all of that, I think we can all agree that's fairly creative. So complaints started to roll in, right? And they're like, no, that's not fair. Cookies aren't physical. Like, what are you talking? So, you had this kind of states trying to manage to do something, and then groups, consumer groups and business groups pushing back. So the states did try, to make some effort to make it possible to comply, right, with the streamlined sales and use tax agreement.
Yeah, the SSUTA was created by a number of states. I think it's got 24 members and 23 full members now. And their idea was, look, if we can simplify and make our sales tax codes uniform and centralize administration of our sales taxes at the state level, and make other efforts to try and make life easier for remote sellers when they're trying to comply, then maybe we can get Congress, for example, to allow remote sales taxes or remote sales tax compliance obligations to be imposed on remote sellers, or potentially just get voluntary compliance from sellers in anticipation of future remote sales.
So SUTA is going to come up a couple times while we're talking. But it reminds me of Apple's thesis that if we put up the iTunes, the music store, people would just assume do the legal thing if it's super easy. So they don't really, they're not going to go to Napster and steal a song and maybe get a virus if they have an easy way to comply with the law. I think this is also kind of let's just make it easier to comply so that you don't have to stay awake at night worrying about not complying. So that's my own addition. Obviously, that's not Paul speaking. That's Karen's goofiness. Okay, Wayfair decision. So then we finally get the Supreme Court weighing in. So let's talk about how we got to the Supreme Court making yet another decision on this matter.
Right. So you had states that were attempting to figure out ways to get sales tax or sales and use tax collections by out-of-state sellers. And Colorado came up with a law that a couple of other states adopted as well, similar type of law that said to remote sellers, if you're going to make sales into our state, we can't require you to collect sales tax, but we're going to pass a law requiring you to give us information about your sales to our residents, including the identity of our residents and the amount of sales that they've purchased from you in a year. And if you don't want to do that, well, this requirement won't apply to a seller that voluntarily calculates, collects, and remits sales tax due on its residents' purchases, or rather the state's residents' purchases from it to our tax authority. So essentially, they said, is the slide notes, either you collect the sales tax voluntarily, or you have to give us a bunch of data about the sales that you've made to our residents to allow us to then pursue the use tax that they owe.
Right.
That case went to court, and at one point went before the U.S. Supreme Court. And what's key there is that then Justice Anthony Kennedy wrote in a concurrence opinion that he believed that it might be time for the court to review the Quill precedent and take another look at that obligation, or that restriction, I should say, on the state's sales tax authority with respect to remote sellers. Okay,
so he rolls out the red carpet saying, we're not going to change anything right now, but if you bring me the right thing to think about, we'll go ahead and consider it.
Right.
Okay, and so what was that red carpet?
Well, right. So this inspires a bunch of states to start crafting legislation that will create a facial challenge to the Quill precedent. One of them is South Dakota, which crafts a law that says that if a seller makes a certain number of sales or a certain dollar value of sales, a remote retailer makes those sales into the state, in a given year, even if that seller has no physical presence in the state, South Dakota is going to require it to collect and remit sales tax on its sales into South Dakota. So that is directly.
So this is a clear challenge to what Quill said, which is you have to have a physical presence. South Dakota passes a law that says, no, you don't.
Right.
All right. So that was called the Kill Quill Bill in a wonderful rhyming scheme there. And as you said, other states pass similar things. And of course, BillTrack50 has a big list of those. So that, in fact, was the challenge that made it up. So let's get to what South Dakota v. Wayfair actually said. I've got the actual decision linked here. If you're interested, you can go read it all. It'll mention those cases that we just discussed. But we will summarize for you what the key elements of the decision actually were.
Right. So that law by South Dakota made it to the Supreme Court and did exactly what it was supposed to do, and specifically what it was supposed to do, which was to get the court to reconsider and ultimately overturn the physical presence requirement. So the court overturned Quill. In Quill, as you may recall, the court already said the due process clause, that doesn't necessarily require physical presence. With Quill, the court said, for purposes of the Commerce Clause, you don't have to have a physical presence in the state to have substantial nexus and for that state to require you to collect and remit sales tax.
But there's still the concern about the burden and if it'll discourage commerce, right? And as a small business, I am personally quite concerned about the burden of keeping track of everybody's sales tax and then figuring out who to mail it to, right? So South Dakota saw that coming, yeah?
Yes, so the Supreme Court overturned the physical presence in Quill, but it didn't really establish any other precedent. However, in the decision, it sort of gave favorable commentary on, or an implicit blessing to, certain features of South Dakota's remote sales tax law and its overall legal regime and regulatory regime with respect to sales tax collection. It noted that South Dakota's law set a minimum threshold. A seller had to make $100,000 worth of sales into the state, or 200 sales into the state in a year, before the state requires it to collect and remit sales tax. The goal of that being to sort of reduce the potential burden on a small seller that only has an occasional sale into the state.
Right.
It also established that the sales tax compliance obligation was not retroactive. So once you meet the minimum threshold, you're responsible going forward. But they weren't going to try and apply this to previous years.
Okay, and I've already made, so in this case, I've already made $100,000 in South Dakota, so now it starts to be worth it to me as a small business to figure out how to pay my tax.
Well, right, it's the law by South Dakota requires you.
Okay, fair enough. But it doesn't discourage me as much, because by then, now it's worth it. Like
right. The hope is that you're either a larger business or you're a business with so much commerce into South Dakota that is reasonable for the state to say you have substantial nexus and you should start collecting and remitting our sales tax.
Okay, so that helps keep it from being a discouragement as contemplated by the Due Commerce Clause. And then, of course, SUDA, as we mentioned before, is trying to streamline all of that anyway.
Right. South Dakota is a member of SUDA. And so it had already adopted a whole slew of measures to simplify its sales tax rules, and also provided, it had the Certified Service Provider program that SUTA states have, where they actually contract with software providers like Avalara to do automatic sales tax calculation for remote sellers. So if you are a remote seller, you can register with SUTA to get assistance from these software providers to help you make your sales tax calculations, and then all you have to do is pay what the provider tells you you owe the state. So all of these features of the law the Supreme Court liked, and it didn't establish any of them sort of in precedent as necessary, but it remarked upon them in a favorable way, which a lot of
but Paul, the implied blessing situation just seems like an invitation for more, lawsuits.
Well, it creates the potential for there to be legal challenges, particularly by people arguing that a given state's remote seller law is too burdensome.
All right, well, let's talk about what we think, what has happened so far, which I called move fast and break things, because of course, the states are like, all right. And when you and I were speaking of this before, you said it's like penguins jumping off a cliff. Everyone passed some bills to try to get their sales tax, right?
Yeah, there was a lot of activity after the Wayfair decision in 2018. That was in the summer of 2018. And after that, a whole slew of states either passed laws that pretty much copied more or less what South Dakota's law had been, because they read the Supreme Court opinion and saw that the court had expressed, a favorable judgment of South Dakota's law. So they said,
right. So they're hoping for the commutative property of implicit blessing.
Right. That if they copy the provisions of South Dakota's law, then potentially their law will be viewed as something that would withstand a legal challenge. And so they either passed laws, or in some cases, they said that they had existing statutory authority under provisions of their own laws that allowed them to say, we can require compliance with our tax regime to the extent allowed under the U.S. Commerce Clause. So they
okay. So that's an important point, because that means not all the states are the same.
Well, all the states are essentially either passing laws or they are applying regulations by claiming that their laws already allow them to more or less copy the conditions that South Dakota imposed.
Right, but that means that they're not doing identical thresholds or even joining SUTA, or like there's, again, now as a small business, I was feeling a little reassured, but now I'm worried again that I still have to figure out what a bunch of different states are doing.
Right. When a state adopts a regulatory decision, usually that's going to be followed up by a law. In the case of remote sales taxes, some of them simply didn't feel they had time to craft their own laws. But when they said they had authority to do it under their existing laws, they generally adopted South Dakota's thresholds, and they generally adopted the lack of retroactivity. And that was similar to what we saw with non-SUTA states, adopting their own remote sales tax laws as well, is that they copied the thresholds, and they also said this is not retroactive. The real question is, for non-SUTA states, did they also make similar simplification measures and accommodations?
Right. Okay. So this map that I've got up is from NCSL, and I've got a link below the map to their whole big description, which is super helpful for which states have taken action. As you can see, it's most of them. But yeah, kind of following through all of that. All right. So states jump in, they're passing laws, and obviously then there's a reaction from the marketplace.
Right. So you had a lot of local business groups or brick and mortar business groups that had sort of more of a connection to businesses in state, stores that have physical locations in states. And they were quite happy about the decision in Wayfair, because obviously they felt that they had been at a competitive disadvantage to remote and online sellers, since those sellers prior to Wayfair and generally had not had to collect a remote sales tax unless they'd fallen afoul of one of these laws that states had passed asserting some form of physical presence. But obviously remote seller advocacy groups like the American Catalog Mailers Association and Net Choice, as we have on the slide, were not very happy. And they argued that even with software that was coming onto the market, there was still a real burden for businesses. For example, to integrate the software, to track all of the different local rules, and if there's potentially an incorrect payment of sales tax by a business, or if a business doesn't realize that it has triggered a threshold in a state, since states don't all have the exact same thresholds, that could create a real problem for sellers with respect to enforcement, such as audits. And they're saying essentially that this is now going to be a major hurdle for small businesses, small online sellers to comply with.
Yeah, I do feel like this is still a concern to me. And then I'm also going to note that NCSL, which is the Council for State Legislatures, they are pretty pro-state rights and letting states figure out what is best for states. So they're on the pro side of this as well. All right, so we've got both sides. So it's not clear that like the waters are still muddy, right? All right, so then you've got Amazon, which is sort of the eye of the hurricane, right? As far as they're the ones mailing out all the stuff.
Right. So an issue for states is that they have these remote seller rules or laws, but the concern is similarly to the difficulty that they had getting individual buyers within their jurisdiction to to pay the use tax they owed. Mm-hmm. They now have a problem getting a lot of small remote sellers to collect and remit, because again, if the remote seller doesn't do a good job tracking how many sales or what value of sales they have into a state in a year, they might not realize that they've triggered a remote seller nexus and an obligation to collect and remit sales tax on their sales into that state. And it's very difficult for states' tax agencies potentially to go after a large number of small sellers that in some cases may not owe a great deal of sales tax to the state on the sales that they make. So,
right. And to be honest, like I'm doing some math in my head. I'm like, well, I do a lot of business in Washington and, trying to figure out like if I'm hitting a threshold. The fact that the penalties won't be retroactive do encourage me to try to get it right and be honest, right? But anyway, sorry, that was a small diversion because I'm doing the math in my head. So please continue. Right, it's hard to go after little people like me for states. Is that going to be a good use of their money? But Amazon's a juicy target.
Right, and so what the thinking is by state policymakers is that a lot of smaller sellers are making sales through these online marketplace facilitators like Amazon or eBay, where the facilitator is essentially listing products, processing payments, in some cases arranging the shipment of the product to the buyer. So the states are thinking these guys are already tracking these sales. Let's go ahead and impose the responsibility on them to actually collect the sales tax that is due on the sales that their third-party sellers make into our states. And another advantage here is that if you essentially declare that the marketplace facilitator is the de facto seller for purposes of sales tax collection, right, even a small business that doesn't make $100,000 worth of sales into a state where that's the threshold, even if it only makes $50,000 a year worth of sales, if it's selling through the marketplace has nexus with the state. So the marketplace can be required by the state to collect the sales tax due on that small seller's sales. So it improves the ability to get compliance, and it improves the amount of revenue potentially that we're going to get from remote sales tax collection and remittance.
But as the seller, I don't have to worry about charging it or collecting it or mailing it or anything. So it makes my product a little more expensive, but that's all.
Right. Well, it reduces your compliance burden. As I saw one of the questions.
Right.
Yes, you will have to file something with the state, but the marketplace will be doing the collecting, it will be doing the remitting. It drastically reduces the risks to sellers, and it dramatically reduces the burden of complying with states' remote sales tax regimes, at least for the sales that you make through the marketplace facilitator.
Which is fine unless you're Land's End and you're selling things from your catalog, then it's still you.
Right. The idea being there, though, that Land's End and some of these other retailers are maybe large enough and sophisticated enough that they can handle their own sales tax compliance without too much of a problem.
Okay, but then there's the liability. What if I'm counting on Amazon to pay my taxes or collect and remit my taxes on the goods that I was selling, and they get it wrong?
So there's different provisions that can potentially apply, and if you know, some of these laws have sort of temporary protections, and there are some provisions to protect the marketplace or the retailer if there's an incorrect calculation. But there are some concerns there. For example, what some of these marketplace laws say to a marketplace: if you accidentally remit the wrong amount of sales tax due on a seller's sales into our state, if you can show that it was because the seller gave you incorrect information, then you're free of liability. And then that raises the question, under what circumstances is the seller maybe going to be liable? And what information are they obligated to give the marketplace facilitator? So there are kinks to be worked out in these laws in terms of things like liability, audit protection, et cetera.
Yeah, so kind of stay tuned. So I put a list of all of the bills in here, and we've got a write-up of what they all do. But again, Penguin-like, the states all thought that seemed like a good idea, and there's lots of marketplace facilitator laws, like something like 33 states have already passed them. Right, Paul?
Yeah, give me 1 second here, because that was as of June, and it's a little bit more.
Okay, so, but comfortably most. We can certainly say most.
Yeah, I think it is now, let's see, where is it? 36 states and the District of Columbia have some sort of marketplace facilitator law.
Okay, so if you're a marketplace, you should probably pay attention to this. All right, so let's talk about between the marketplace facilitator laws and the just straight up, states passing their remote seller laws. I called this a mad year of chaotic results, or chaotic quilt of results. So now what, right? That leaves me still not quite sure what I'm supposed to be doing. So there's a lot to be worked out, as you mentioned. Well, let's just go through some of these things. We've got a lot of definitions. We've got all the thresholds, and we've got like what counts.
Right.
Right.
So there are some things that need to be clarified. As we've already mentioned with marketplaces, for example, who's liable in what circumstances. Particularly, here's another thing for marketplace facilitator laws. If too much tax is collected on a sale, where do buyers go for a refund? Is it marketplace? Does the seller have any responsibility? How do you define marketplaces? For example, some states have two categories. You have like a marketplace facilitator, which is like an Amazon, which puts the products up, arranges the sale, actually processes the financial transaction, and in some cases will actually do the shipping itself. And then you have entities like referrers, which really only list sales and sort of facilitate them, but payment may be processed by another entity and shipping may be done by the seller. So there's sort of a gray area there as to how that's going to be defined. And then for remote sellers and remote seller laws, you still have questions. For example, California doesn't have a $100,000 sales threshold; it has a $500,000 sales threshold. So for California, if you have $500,000 worth of sales in California, you have to begin collecting and remitting the state's sales tax. And the reason why is in part because California is a much larger market, so it's much easier for any seller to have more sales in California than a state with a smaller population. So there may be exploration as to whether those thresholds need to be changed for states and on what basis they should be increased or kept at roughly South Dakota's level.
And all of that is just the states don't want too much protest from anyone, right? From business groups, from consumers. They certainly don't want the federal government wading in. Like, they want to make this something we can comply with at some reasonable amount of like a reasonable amount of effort, so that it can all just kind of go along and they can start getting their money, right?
Right. They're very happy with the Wayfair outcome, and they're not interested in creating a whole bunch of new fights. So we may also see some non-SUTA states in particular try and maybe simplify their sales tax rules a little bit. We saw this, one story that I wrote this year was on Arizona, which passed a combo remote seller and marketplace facilitator collection law. And one of the things Arizona did was say, hey, we have this local, sales tax codes, and we're going to say that the state's code is controlling in certain circumstances to try and make it a little bit easier for remote sellers to calculate the taxes that they owe, at the state and local level for their sales into the state, or the taxes that they're responsible for collecting and remitting. So we may see more of that. And we might also see some other states start coming up with certified service provider programs. As I noted, SUTA states contract with these software companies to help do sales tax collection, sales tax calculation to make it easier on the sellers. And I think I've got it here somewhere. There is another state, a non-SUTA state, that is doing this. Pennsylvania, I think, has its own CSP program. And I actually spoke with the Sales Tax Institute yesterday, and I think they said that Illinois is looking into one, and New Mexico as well. So there might be some non-streamlined sales and use tax agreement states that start trying to emulate more SUTA behavior in order to mitigate, the burden, improve compliance, and reduce the risk of congressional interference or a lawsuit.
Well, I appreciate that. And I, in my normal business, go, like 50 state kind of surveys. Oh my gosh, I'm glad I have an accountant. It's just so much. Okay. So, what is on the radar for what might either hold this up or help this go forward? Let's start with, I don't know, the states that had no sales tax in the first place and don't appreciate other states trying to collect money from their residents, right?
Yeah, particularly New Hampshire. So obviously there's some states that don't have sales tax. And although you might just think they're not affected by this, New Hampshire in particular really doesn't like the Wayfair decision and has actually passed legislation that would, it claims the authority to review other states' remote seller laws and determine if they're too burdensome or not. So we'll see where that goes. But New Hampshire has taken a particularly hostile stance towards other states' efforts to apply remote sales tax collection and remittance responsibilities to its sellers that make out of state.
Goodness. Okay, so they're like, we will be the judge. All right. Let's talk about what Kansas has done that caught your notice.
Yeah, well, let me actually touch on net choice and the ACMA.
Oh, sure.
That is, so net choice and the American Catalog Mailers Association, obviously, we're not big fans of the Wayfair decision. And they, in July, I think it was July, noted that they were looking to raise money for a potential challenge. And it looked like the idea they had is that a lot of states, particularly non-SUTA states, haven't adequately simplified the burden of compliance. And I don't know where this effort stands right now, but they were interested essentially in trying to create a legal challenge that would argue that if you're not a SUTA state or you haven't taken significant measures to simplify the burden of compliance with your sales tax regime, then you really weren't satisfying the Commerce Clause, even though the court had struck down physical presence in Wayfair. So that's sort of interesting. I don't know where that is at this point, but there may be either as net choice in the ACMA or some other entity that ultimately does bring a suit against particularly a state with a more complex sales tax code to argue that, okay, sure, you don't have to have physical presence, but you can't make it so burdensome that it's a serious imposition on remote sellers. So it remains to be seen if somebody tries to make a legal challenge to a remote seller law on that basis in the future.
Right. Okay, well, it's certainly worth watching. Moving on.
Yeah, and then on to Kansas. Kansas is sort of interesting. They did not pass a law this year, a remote seller law, but their tax department ultimately came out with regulatory guidance saying if you make sales into Kansas remotely, you have to collect and remit sales tax. Now, Kansas is a SUTA state, but its regulation doesn't have a minimum threshold. So it's possible that law could be challenged.
Boom.
And that,
threshold.
it's probable that the legislature will address that before it goes too far. They did have two laws that were proposed this year. They didn't pass for other reasons. But if there was a suit over the Kansas guidance, it would be kind of interesting because that would press the issue of the minimum threshold.
Roger that. All right. So, and yes, maybe get a floor on the minimum threshold, right?
Right.
Okay. And what has Congress done in all of this?
Well, Congress, there has been some legislation introduced in the wake of Wayfair. And one of them is the Online Sales Simplicity and Small Business Relief Act of 2019. And that potentially, if it moves forward, would provide more protections to small sellers. For example, it would say you have to have about $10 million in annual U.S. gross receipts to be required by any state to collect and remit sales tax. Whether that moves forward or not remains to be seen. Again, Congress didn't have any real interest in jumping in prior to Wayfair, and so it's questionable if they want to get involved in state remote sales tax rules now that the court has allowed it.
But Paul, every day they get more functional.
Yeah, right. Well, and so one of the complaints is that Congress just doesn't have the motive to jump in here. But it's at least theoretically possible that if states' remote seller laws proved to be too much of a burden or created too much chaos, that Congress might be moved to respond. We just haven't really seen any indication that that's going to happen yet. And there's another bill that we've got there, but I'm going to mention that on a later slide because it actually is more relevant in a different context.
Roger that. And then you've got the international sellers, and are they going to be able to get leverage to get,
Yeah, so,
or whatever to also collect sales tax?
We don't have the same authority over a seller in another country that a state does, if it has a law that requires a remote seller somewhere else in the U.S. to comply. So the thinking by some experts is that we may be able to get compliance from international sellers because they just decide to comply with these laws. They don't want to be on the wrong side of state laws because they sell through marketplaces that are subject to marketplace collection requirements. And there would be collection on their sales as a result of that. And also just that particularly if you're a larger seller, it might complicate your future business with the U.S. if you end up with a giant unpaid sales tax liability in one or many states. So the idea is that potentially this will apply to international sellers as well, even though we have less authority over them. U.S. states have less authority over them than a seller that's in the U.S. somewhere.
But kind of like the rest of this, we'll see.
Right.
Okay. And a little bit broader, as you mentioned, there's some things that aren't directly sales tax.
Yeah, so states have applied other business activity taxes like income tax or gross receipts tax to businesses that don't necessarily have a physical presence in their state. The physical presence rule was really very specific to sales tax. However, a lot of experts that I've spoken with have said that by getting rid of Wayfair, really we've created a situation where states are going to feel more comfortable, by getting rid of the physical presence requirement via the decision. That as a result of that, states will feel more comfortable using economic nexus for other taxes. And so there's some question now as to whether the decision in Wayfair, for example, might mean that if you were a retailer making a bunch of sales into a state, could that state try and apply its income tax to you as well, not just the sales tax? And we have a federal law, Public Law 86-272, which says that under certain circumstances, if you're a retailer and you limit your in-state activity to essentially soliciting for sales, and you're making sales out of state to in-state buyers, that you don't have to pay income tax. But some of the experts I've spoken with have said that because of the way that the online, sort of online commerce is changing, some businesses may not still qualify for 86-272's sort of narrow protections. And of course, 86-272 is specific to income tax. So for example, gross receipts tax, that wouldn't be covered by 86-272. We've noted that a couple states have actually changed their economic nexus threshold for applying business activity taxes. Hawaii passed legislation this year to apply its income tax to businesses using the same threshold that it uses for remote sales tax collection requirements. And Washington, which has a gross receipts tax that it calls the business and occupations tax, that they changed their threshold for that tax to the same as they're using for remote sales tax collection requirements. So we may see a broader evolution in business taxes that is influenced by the Wayfair decision and the elimination of the physical presence requirement as well.
You know, this is a roller coaster. I feel a little better, and then I feel worse again. And it's not that I want to pay my taxes. It's just figuring out my taxes, right? Okay, so we've got a bunch of links for you to help you sort through everything that we just talked about. And so hopefully you will find all of these pretty helpful. So we've got some different statements and summaries and whatnot of what Wayfair is all about. We've got some resources for you for if you're an online seller or a remote seller, not even online. Information about SUDA and SUDA compliant software that you can check out, especially that first link, you're going to check that out. And then other write-ups we've done, including the companion blog post to this piece, to this webinar that's going to go through everything we talked about, and it's got all the links in there as well, sort of a one-stop shop for all of this. And we have reached time for questions. So Michael, if you're ready to pipe back in and tell us what people are saying or asking or thinking, or are you as worried as I am?
I'm always worried. Taxes are and me never get along. We have 3 questions actually, kind of all related. People asking about non-physical goods like subscription services, newspaper paywalls, Netflix. Are these products taxable?
Sure, BillTrack50. You know, selling a subscription. I don't have a tangible good. I bet Paul's going to say that depends on the state.
Yeah, I mean, I guess it would depend on whether this is a state that taxes services and whether they're considering, for example, digital goods or subscription services to be subject to sales tax. But that's
like a whole other wrinkle, right? Like the threshold, what counts against that? Like it, yeah. So for each state, it's not just what is their tax rate, but also what do they tax?
Right. And if a state is saying we apply our sales tax to digital goods or services, then potentially if you have a certain number of sales into a state and you have nexus according to that state, then you'd be required to collect and remit for those transactions as well.
Okay, and I am in, I incorporated in Colorado, and I'm pretty sure. I mean, I pay sales tax on sales I make in Colorado to Colorado customers. So, anyway, probably some states I'm going to have to pay sales tax, but I don't know which ones. And I don't, yeah, so I'm going to have to use some of those resources to figure out.
I want to mention something.
Sorry, Paul, go ahead.
Yeah, I'm Paul Miller with the American Catalog Mailers Association. I missed this, but he added this note during the presentation. He says, ACMA here dash, it's test case litigation. We're still in the fundraising stage. So that is, I mentioned the ACMA had been looking to raise money for a potential legal challenge. That is, I guess that's still in the fundraising stage is what Paul just added here.
Fair enough.
Right. So I guess that's good.
One other question, I know you touched on it, but I don't know if you want to expand. The marketplace facilitator, we have an attendee who sells through a marketplace facilitator. Oklahoma has told them that the facilitator will file the taxes, but they must continue to file returns. Says, are you seeing this requirement with other states as well? the vendor below the marketplace facilitator having to file exempt returns to note the sales amounts?
Yeah, so I believe that a lot of marketplace facilitator laws essentially require the marketplace to calculate, collect, and remit the tax to. But some of them, at least, are going to require the actual seller to also file information with the state. And yeah, I'm not sure how many, but I've heard of that. Oh, and I guess I've got a note here from Michael O'Brien. It says he'd like to answer this question live.
Oh.
I hit the wrong button. I do have a question though.
Oh, okay.
I do have a question. As somebody who sells services, but works in a lot of different states, where do we figure out where the nexus is? Would you do it based on where the purchaser is, where the biller is, or where the work is done?
Yeah, well, this is a complicated question that I hear getting raised at tax conferences all the time, and has to do with sourcing. And essentially, it's going to be based on the state's definition. And this I think is another sort of complex area that is going to see a lot more work. When it comes to compliance, essentially, with a state's sales tax rules, I guess the most conservative thing to do is to just try and follow the state's rules to the best of your ability. But this larger question of where do you trace the sale of a service? Is it where the service is performed? Is it where the benefit of the service is received? That's a larger question, and that even goes to questions of trying to apportion, or trying to determine how much income tax a business owes to a state.
Oh my God.
And so, sorry, I can't give you a more specific answer than that. But,
all right. So
states have their own rules where they try and lay that out, particularly for income tax. So states with sales tax, if they're taxing services, would be responsible for providing guidance for sellers with respect to that issue.
Right. Okay. So we've got another note from Paul, attendee Paul, not speaker Paul, mentioning that he's with the Catalog Mailers Association. If you want, so we've got Congress tells us they're not hearing from anywhere near enough of their constituents to give them a motive to jump in. So that is from his point of view, but fair enough. So Congress isn't, as we were saying, necessarily motivated to pass any laws to make this uniform across the country. They're not hearing from, or to, make it not a thing anymore. So they're not hearing from their constituents. And you're probably mostly on this call constituents, so take that under advisement. All right, and one last question from Adrian.
Yep, it's a follow-up to the subscription services. They're asking if states don't yet specify digital goods, does that mean subscription services are exempt from states' nexus and thus don't have to pay state taxes?
I'm sorry, Adrian. I just saw your question pop up on the screen. Can you sort of repeat that? I was looking at the wrong in the wrong area. But it's about subscription services.
Yes, they're asking. This is Michael again. It's a follow-up to the subscription services. If states do not yet specify digital goods, does that mean that subscription services are exempt from those states' nexus laws and don't have to pay state taxes?
Yeah, that's really a question to verify. With the state tax authority. Again, they'll have guidance. So some good resources like the Sales Tax Institute, the SSUTA, and Avalara, which is one of the technology providers, is also pretty good. But when it comes to trying to comply with state rules, I don't think there's any shortcut. You need to check the state, what it taxes, if it taxes services, and if it does, what its guidance is with respect to digital goods and services. and whether it counts subscriptions, like an online subscription, as a taxable sale. So that's going to be very specific to each state and depend on what they've decided to apply their sales tax to.
I guess I know what I'm doing this weekend. Okay.
And you do have a lot of these resources, like Avalar is pretty good, and Suit is pretty good. And we
yeah,
have
you should be able to Google them up, or these are some great places to start.
Right.
Well, thank you everybody for coming. Hopefully this at least gave you some context about what's decided and why, and the guiding principles, as well as what's still up in the air, and also maybe some things you can do. And we've got some additional reading if you're interested. Tax Notes was nice enough to move some articles that might be interesting to you outside of their paywall. So these articles are available for all of you to read. If any of these topics deserve more attention from you in your business. So thank you all again for coming. Thank you, Paul, so much for sharing all of this information.
Absolutely, and thanks for having me.
And Michael, thanks as always for your wrangling.
Hey, I was happy to be here.
All right, and feel free to drop any of us questions. I think you know probably who you're going to want to write to as far as your questions. And obviously, if you have specific legal or tax questions, you're going to want to try a lawyer or an accountant if you have a very specific business situation you'd like. But if you have general, where do we think things are going, obviously, we're happy to chat with you about that. So thanks, everybody, and we hope to see you at our next webinar.
Yeah, and really do take a look at the resources on the slides and in the blog post, including the text, because there's a lot of great places there to get some good summary information, and also the Avalara and the Sales Tax Institute. They have entire spreadsheets they've created of marketplace laws and remote seller laws that will really give you a good overview of what the thresholds are, the implementation dates, all of that sort of important data that you can use to start sort of vetting your situation.
Absolutely. We're not trying to just inspire fear. We are definitely trying to help you too. So hopefully these resources will come in handy. All right. Thanks again, everybody, and we will see you next time. Bye, Michael. Bye, Paul.
Bye, guys.
Bye.